Good day everyone. We are from group 15 and our group presentation title will be Legal Liability. Our group members are Janani Aravindan 046245, Noor Sumaya binti Muhammad Noor 047953, Raihan Akisha binti Muhammad Fauzi 047037, Raja Noor Farhana Gayyum binti Raja Azamuddin Aznam Shah 047593 and Vaisumita anak perempuan Raju 046903. Our case 1 title will be Legal Liability of Audit Committee Members in US Shareholder Derivative Cases, Lesson Learned from Recent Litigation. This case emphasizes US shareholder derivatives in which members of the audit committee were defendant. In such cases, three grounds for the liability of the audit committee were alleged. First, violation of the fiduciary duties of care, elegance, or good faith, which may include failure to provide sufficient oversight. Second is infringement of the Stock Exchange Act by making a false statement about the selling of a security, and third will be infringement of the C because members of the audit committee may be considered to be control person. There are three reasons for the audit committee members' legal responsibility. First, in common law basis, audit committee members owe a duty of care, a duty of elegance, and a duty of good faith to the company and its shareholders. The main accusation of membership of the defendant's audit committee does not endorse an assumption that the member of the audit committee breached a fiduciary obligation. Second will be statutory law. It is unlawful to make an untrue statement about any person in connection with the purchase or selling of any security in the commission of a fraud. Members of the audit committee can be responsible for material false statement intentionally made in relation to the financial statement of their company. Third, also statutory law. Any person controlling any person liable under the second ground shall also be jointly and severally liable with and to the same degree as the controlling person unless the controlling person has acted in good faith and the unlawful act has not been caused. In general, membership in the audit committee standing alone is constitutionally inadequate for the responsibility of regulating persons. A successful claimant must state additional evidence indicating that the members of the audit committee had a comparatively higher degree of authority in accountability.
Case 2 is about Pension Trust Fund for Operating Engineer versus Coles Corporation. What is Coles Corporation? Coles Corporation is an American department store retail chain with over 1,100 locations. The company was founded in 1927 as a grocery store and in 1962 transitioned to retail by opening its first department store. Coles ran over 1,000 department stores across the United States. About 65% of those stores are leased, a fact that makes lease obligations a significant component of Coles' financial picture. In this case, the Pension Trust Fund for Operating Engineers alleged that Coles and two of its executives, which is CEO Kevin Mansell and its CFO Wesley McDonald, defrauded investors by publishing false and misleading information in the lead-up to the corrections. There are three sets of errors occurred in Coles Corporation. First in 2005, second in 2010, and third in 2011. The first and third of these corrections were material and required the restatement of several years' worth of financial statements. The second was comparatively minor and required an adjustment to income in one quarter. The details of the errors are: in 2005, misstating the start date of the lease. In 2010, also same error with 2005, which misstating the start date of the lease but this time only led to minor restatement, and in 2011, the errors leading to major restatement wholly unrelated to problems of 2005. However, the pension trust fund complaint fails to prove fraud of Coles Corporation because the evidence failure to meet the enhanced pleading requirements for scienter imposed by the Private Securities Litigations Reform Act (PSLRA), and they believe that the errors resulted from careless mistakes at the management level rather than from an intent to deceive or a reckless indifference to, although the statements were misleading. In this case, the treatment of these leases has caused Coles accountants and external auditors some troubles in recent years. The company was forced to adjust its accounting practices 3 times in 2005, 2010, and 2011 to bring its books in line with generally accepted accounting principle (GAAP). That is all from us. Thank you.